rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We're here this morning in the case of Vazirani versus Annexus. It's our case number 1, CV140815. These proceedings are being audio and video recorded, so we'd ask that you identify yourself when you approach the podium. Each side will have 20 minutes. Appellant will be responsible for reserving whatever time you'd like for rebuttal time. We have conferenced this matter. We've read the briefs. We hope we're familiar with the facts and the arguments. And with that, we'll proceed.
May it please the Court, my name is David Bray. I'm with the Dickinson Wright firm, and I represent Adil Vazirani and his business, Secured Financial Solutions, LLC. I'm going to do my best to try to distill and focus on a few key points out of an appellate record that consists of approximately 190 pages. Mr. Vazirani is a remarkable immigrant success story. He immigrated from Bombay, India to New York. He's been in the insurance and annuity industry since 1990, and presently he's one of the top 10 annuity agents in the country. During the period of time he was affiliated with Aviva, 2006 to 2008, the record reflects that he was recognized by Aviva as one of their top agents. He personally produced over $10 million in premium over 2 years, and his team produced approximately $100 million in premium.
Counsel,
yes.
Can I ask you some factual questions, please?
Yes.
Can you hear me? Okay.
I can.
Sometimes I'm a little soft-spoken. When you say his team, I assume you're referring to his downline agents?
Yeah, in the industry, the people that work below you, you have contracts with insurance carriers, and the people in his team contract with the carriers through him such that he would receive an override commission.
Right. So in the opening brief, there's a number of statements that say SFS had a contract with Aviva, SFS had a contract with downline agents, Vazirani and SFS had contracts. And when we went through the record, I had a hard time finding anything that showed SFS had contracts with anyone. As I understood Mr. Vazirani's deposition, he basically said SFS is a brand, and it didn't have contracts with anyone. It didn't have revenues. It didn't have assets. Is there anything in the record that shows SFS had a contract with Aviva or had any contracts or prospective contracts with anyone?
I'll answer that in two parts. Number one, there is evidence in the record that Mr. Vazirani personally had a contract with Aviva.
Yes.
I don't think that's in dispute. And number two, with regard to SFS, while it's true that SFS did not have a contract itself with Aviva, it did. I believe the record does reflect that it had what were called independent marketing program agreements with downline agents.
Where is that in the record?
Standing here this morning, I don't know. If you ask Mr. Parrish if the evidence below showed that SFS had marketing program agreements with its agents, I don't think he would dispute that it did.
Marketing program agreements?
Yeah. It covered the intellectual property belonged to SFS, and it created the terms and conditions under which people in Mr. Vazirani's downline could use the marketing material. Also included terms like 100% of the business had to be put through Vazirani approved carriers.
Understand. Okay, but how does that work if they don't have any? I think the deposition was doesn't have any assets, doesn't have any books, doesn't have any records. I mean, is it just a shell that there's a contract with, and everything really goes to Mr. Vazirani?
I suppose you could characterize it that way, at least with regard to SFS, that the monies flow through Mr. Vazirani or another entity.
Okay.
But again, there's no dispute that SFS itself had contracts with these downline agents.
The other factual question I had was, well, I guess two other factual questions, or three factual questions. Let me just try to go through them so I make sure I get to ask them.
I'm going to have to take notes now.
I'll get just one at a time.
Okay.
Obviously. Who are the prospective contracts, the prospective business advantage? I had a hard time pinpointing where in the record someone said the prospective business advantage that was, or agreement that was interfered with was with X. I mean, I understand that Mr. Vazirani had a contract with Aviva, and he had contracts or had arrangements with these downline agents who he would get a commission from, or an override commission from. But who were the prospective? What were the prospective agreements that were interfered with?
The theory there, Your Honor, was that, again, for somebody in Mr. Vazirani's position, the downline is very important.
Sure.
And it's very important, even though, for instance, Mr. Vazirani, in order to successfully recruit additional agents to his downline, it was an impediment to him and to those efforts not to be contracted with one of the largest insurance companies in the country. So those would be the prospective contracts. It would be other downline agents that chose or would choose not to become part of Mr. Vazirani's downline because he was no longer had the ability to offer the full panoply of annuity products that they would be interested in.
Okay, so he wasn't able to identify anyone that he was negotiating with, just saying, but the idea was, without the Aviva contract, I can't get these agents to sell my line.
I think that's the limit of his testimony there, though I believe there's evidence in the record, and Mr. Vazirani testified that as to certain agents in his existing downline, he lost a number of agents as a result of the fact that those agents no longer wanted to work with him because he didn't have the ability to sell the Aviva product, whereas appellee defendant Advisors Excel, for instance, if they affiliated with Advisors Excel being a favored carrier for Aviva or IMO for Aviva, did have the ability to continue to sell the Aviva product.
But once Aviva canceled his contract, Aviva also canceled all the downline agents. Is that right? My understanding was there was a letter that went out, or a follow-up letter said, we are canceling your contract, Mr. Vazirani, and the letters were sent to all the downline agents saying you're no longer...
They did, and as a result of that, the downline agents would then choose to contract with another, this is our damage theory, Advisors Excel or another entity, and eventually be able to recontract with Aviva, whereas Mr. Vazirani never had the ability to recontract with Aviva.
Right. And then the other...
That was number one? That was number one, okay.
You've answered a couple of them.
Okay.
My last one was there, I could not find on the defamation claim, defamation per se claims, I couldn't find a motion anywhere to amend to say, okay, we're just going to allege defamation. I mean, obviously, as I understand it, Kansas doesn't recognize defamation per se. And if Kansas law applies, I'm not saying it does, but assuming it did, all the defamation claims would go away. Was there ever a motion to amend to say we also want to allege just a plain old defamation claim?
There was not. Okay. So I think, in fairness, the record is that our defamation claim is a defamation per se claim, and our argument is that even as to the Kansas-based defendants, Arizona law should apply, and as to the Arizona-based defendants, Mr. Schertz, and the Annexus Group, certainly Arizona law should apply because they have very little connection to Kansas.
Sure. Okay. Thank you.
You're welcome. As your honors know, Aviva terminated Mr. Vazirani's contract in November of 2008. There was then back and forth amongst lawyers for each side, and the termination, by the way, was without cause. So even though appellants or appellees in their answering brief identify possible causes, when it came down to brass tacks, when they made the decision, we're going to terminate Mr. Vazirani, they could have terminated him with cause under the contract with him, and that would have had various consequences, and they, that was an option that they chose not to pursue. Instead, they chose to pursue a termination without cause, which I think undermines their argument that factually, there was all these bases that they could have terminated him for cause. If they could have, why didn't they? So when pressed in terms of the reason for Aviva's termination of Mr. Vazirani's producer contract, pre-litigation, again, they don't say this was because we were upset about how you recruited Advisors Excel agents. This was because of the agent release that was sent for the Annexus contract by accident. They didn't say any of that. They said the reason that we're terminating your contract was we wanted to focus on key core groups of Aviva going forward.
That's partially right. I mean, they also said we want to focus on, we want to move out of the annuity, right? I mean, we no longer want to be pushing the annuities.
Sure. I mean, certainly I don't think there's a dispute in the record that one of their objectives was to, and one of the Aviva witnesses testified as to the percentage, but they were seeking to reduce the volume of their annuity business, not from, let's say 100 billion to zero, but 100 billion to 60 billion. I think they were looking to slash it by 40% or something like that.
And that's what the Heights Court found too, right?
Yes, they did find that.
Yeah.
But again, Mr. Vazirani, that stated reason for termination was entirely pretextual. And the reason that we know this is two reasons. One, Mr. Vazirani was affiliated with Financial Independence Group, which is based out of North Carolina, and which Aviva recognized was one of its key core groups. And number two, through discovery, the discovery confirmed that Aviva's stated reason for termination was entirely pretextual, and that, in fact, Mr. Vazirani's termination was not due to changing market conditions. It was not due because of a desire for them to focus on key core groups, even though, by the way, he was part of a key core group. It was because they were doing it at the behest of appellees who had their own personal animus towards Mr. Vazirani. For example, with regard to appellee CMIC, which, interestingly enough, was actually a wholly owned subsidiary of Aviva at the time, the president of CMIC sent an email to Mike Dickerson of Aviva and basically said, we're unhappy that Mr. Vazirani is coming behind other non-registered agents and making complaints or threatening to make complaints because they're providing securities advice in violation of the 1940 Act, because the money that's funding the annuities comes from the sales of qualified retirement funds or securities. So again, from our perspective, Mr. Vazirani was acting as a whistleblower, and this is a very large issue in the industry and has been an issue in the industry. But there's a citation in the record regarding Arizona law, which is if you provide advice regarding the sale of securities, you're providing securities advice and you need to be licensed. So I think there was certainly a good argument that agents that are providing advice regarding the purchase of annuity when they know that the funds are coming from the sale of securities or mutual funds in a retirement account is violating the 1940 Act. Mr. Tripsy said this guy is bad for the industry. I would personally work to make sure he's terminated everywhere. Another email. Can you get me Anil Vazirani's Aviva contract terminated? I assume you know why. Guys, we really need to wrap up the deal to kill Anil V.
Counsel, can I switch to the statements by Annexus defendants? Is it Phil Graham? Is that
Sure.
And Fig?
It's primarily Ron Schertz.
Schertz.
Yeah.
Schertz, but he was with Annexus, right?
Yes.
Okay. So Schertz, in October 2008, as I understand it, Schertz contacted Graham and said, I'm just going to summarize briefly or paraphrase. He called Vazirani certain names.
A lot of F-bombs. A lot of F-bombs.
Yes. Or at least 2 or 3 or 4. And then he says, he's toast after today. Aviva is done with him. His Aviva's contract it just got terminated. He's just done across the board. He's done. Nobody wants to do business with a guy. I mean, any companies, but they're being held hostage at premium. And I wouldn't do business with him. for a 5-point override. Some of that's pretty hyperbole. There's granted it's and obviously, my understanding is FIG never said we're going to terminate our relationship with Fazzarani.
Yeah, that's not part of this case. There's no claim that FIG,
Right,
Financial
understand
Independence
that.
Group.
So, right, but so there's a defamation per se claim based on those statements. Some of them sounds. What's your best argument that? I mean, the hyperbole, like he's the hyperbole of calling him names is defamation per se.
I think our best argument is you got to look at all of those statements in the entire context of the conversation. And while I admit the line between hyperbole or statements of opinion versus statements of provable fact can be a gray one, I would say words like nobody wants to do business with him is provably false.
But if you simply say, you would agree that he's an idiot isn't defamation per se, or nobody likes him, is that defamation per se? Is it just that it's nobody wants to do business? It doesn't seem very different than no one likes this guy. It seems like a lot of hyperbole.
And again, I think the best argument I can make is the argument that I made in the brief, is that if you take the entirety of the conversation in context, what's really being communicated is that Anil does not have the ethics or ability to perform adequately in this field, and that nobody wants to do business with him as a result. So I'm not sure I can say much more than that. Okay. I certainly recognize the argument that there are some statements of opinion in there, like I think. But I think that calling somebody a greaseball, and again we cited the Random House definition of that. That's.
It's a defamation per se.
I would argue that it is.
Okay.
I'm down to 4 minutes. I would like to reserve a little bit of time. Does anybody else have any questions? Okay. Thank you.
May it please the Court. Mike Parrish on behalf of Creative One Marketing, and my intent here this morning is to address many of the arguments on behalf of all of the appellees, but also I'm going to leave time for Ms. Lovell, who will address some of the issues specific to the Annexus defendants, and we'll see if Mr. Alexa, who represents Advisors Excel, needs to address anything. If I may, I'd like to start, Judge Kessler, with the questions you asked about SFS Secured Financial. Here, I think, are the facts. As Mr. Brake agrees, there's no contract with Aviva. There are something called, and there is something called these marketing program agreements between between SFS and certain downline agents. But SFS was paid no override commission by Aviva, and Aviva's termination of the ability of those downline agents to sell Aviva products didn't affect at all the performance of these SFS marketing program agreements that SFS had with the downline agents.
Why?
Because those agreements didn't have anything to do with were not an agreement that says Fazzarani gets an override commission on our sales. It had solely to do with SFS agrees that these agents can use certain marketing materials that have the SFS brand, and that if they leave the SFS team, they won't use those marketing materials otherwise.
Okay, so if and that was SFS's contracts with these downline agents was simply to provide material so they could, SFS labeled material so they could use those. But by using those, they didn't pay any money to SFS to do that. It was everything that, it was just a marketing tool. And because they then would generate business through Aviva, they would get, Aviva, Mr. Vazirani would get override commission.
That's exactly right. And keep in mind, Your Honor, that these downline agents are writing business for a variety of insurers.
For sure.
And so the termination of their ability to sell Aviva products had no effect whatsoever on these marketing program agreements that they had with SFS. None whatsoever.
Okay. Were the SFS brand, was that limited to Aviva products?
Oh, no. Has nothing to do with any particular insurer.
Okay. Okay, thanks.
Your Honor, I'd first like to focus on the tortious interference claim. We're dealing with a claim of tortious interference with an at-will contract and a business expectancy based on an at-will relationship. There are multiple grounds for affirming the summary judgment. One, the interference is not improper as a matter of law. Secondly, the Heights case established that Aviva had good business reasons and was motivated by them in terminating Vazirani's contract. That's issue preclusive here.
Because they wanted to focus on the non-annuity line, is that right?
That's correct, as well as the enforcing the rules that were violated by Vazirani is another part of the business reason. And third, even if it were not for Heights' preclusive effect, the undisputed facts in the record prevent a reasonable juror from finding resultant damage through any kind of assurance that the contract would have continued in effect.
Could I ask you about issue preclusion?
Sure.
It seems like Heights simply holds that Heights and Canfield were not motivated solely by personal reasons. But how does that translate to other defendants' actions? So they had some business reasons, but they may have had they simply were not solely motivated by personal reasons. But that doesn't seem to necessarily answer the question in this case.
If Your Honor, if you don't mind, I think the best way for me to answer that agreement is to kind of lay out what our reasonable assurance argument is. And that is, we are not arguing, at least in the summary judgment context, that no reasonable juror could have found that the appellees were not a cause of Aviva's decision in November of 2008 to terminate the contract. What we are arguing is that, as part of his submissible case, is that damage resulted from the termination. Here, he was informed in November 2008 that the contract would be terminated. It was not terminated until April 2009, 5 months later. Our position is that in order for him to show that damage resulted from the interference, because this was an at-will contract, which the law says you have no legal assurance that it will continue, he has to have some proof that the contract would have remained in effect beyond April 1, 2009. Now, his argument is, well, I've been such a good producer. That's why I have some assurance. And our position is that because Heights established that Aviva had good business reasons for terminating Vazirani's contract, it precludes any Vazirani from proving that there was a reasonable assurance that his contract would not have been terminated within those some point within those next 5 months between November 2008 and April 2009.
So it's more going, I suppose, sort of towards damages in that he has to prove that the contract, you're suggesting that he would have to prove that the contract would not have been terminated but for the...
And we don't suggest he has to prove that with any certainty, Your Honor, certainly. But based on the language that's in Restatement Section 766, Comment G, that Wagenseller cites, we think that because there's no legal assurance that it will continue, it's closely analogous to a prospective contractual relationship. Some evidence that the contract will continue is required, and what the case law use in that closely analogous context is some reasonable assurance that the contract would have continued. And
Well, it's a causation argument then, isn't it?
I beg your pardon, Your Honor?
It's your reliance on Heights is a causation argument.
Yeah, I think we characterize in the brief as causation and resultant damage.
Right, because if I understand what you're saying, as I understood your briefs, you're saying if Heights held that Aviva would have terminated the contract and did terminate the contract based upon a business reason unrelated to what these appellees did, then there's no reasonable assurance that he would continue, the contract would continue.
Exactly. We're not saying that Heights established that that was the only reason or that the defendants had nothing to do with it. Our point is just exactly as you said it, Judge Kessler, that there's no reasonable assurance that the contract would have continued because Viva had good business reasons for terminating it. And
so how do you get around this idea of, well, if there's a good reason and a bad reason?
well, Your Honor,
The jury.
I mean, the way I understand the law is, and I'm thinking most specifically about Wagenseller, I mean, certainly talks in the context of the employer's ability to terminate the employee in that case, that you can do it for no cause, good cause, but not for bad cause. For bad cause or improper cause.
Improper, right.
But that discussion is in the context of the termination of the employee. It's not in the as I read the law, it's not in read Wagenseller, it's not in the context of tortious interference. Where improper comes up in the context of tortious interference is whether the defendants, the third party's interference was itself improper. And so the way we look at Heights establishes all that we need to establish, establishes all that's necessary that Vazirani can't make a submissible case on causation or resultant damage.
Because of the reasonable assurance idea.
That's exactly right.
Okay.
And then secondly, putting aside Heights for a moment, and I do think Heights is issue preclusive, and Mr. Bray agrees in his brief. We both agree on the law on issue preclusive, and we both agree that that what Heights is issue preclusive as to is that Aviva had some good business reasons for the termination. Not that it was the only reason, but that Aviva had some good business reasons. So we do think Heights is issue preclusive for those reasons. But then separately, putting aside for a moment the effect of the preclusive, I'm going to pause, Judge Kessler.
No, go ahead. Go ahead.
Oh, okay.
Keep talking.
I know that expression, so that's why I was. I'll move on, but I'm happy to come back and answer any.
Keep going.
Okay. But then separately, putting aside the preclusive effect of Heights, the undisputed facts don't provide any basis for reasonable assurance that the contract would have remained in effect beyond April 2009. And our argument is not that there was no possibility that the contract would have remained in effect.
What in your view type of evidence would have to be presented to present a colorable claim?
Well, I'm not certain, Judge Catani, because I will tell the court that first of all, we have the undisputed facts regarding the flagrant rule violations. We have the undisputed facts regarding the mass terminations, the business plan to conserve capital and slow down annuity sales in late 2008 and early 2009. By April 2009, Aviva had terminated thousands of agent contracts and hundreds of groups. Some of them were larger producers than Vazirani. Nearly everyone at Vazirani's commission level was terminated, and some of them were affiliated with FIG just to the same extent that Vazirani was. So,
would it have to be a case where there's some testimony from someone or some document that said we're planning to continue this contract, and there's some intervening statement, and now would that get you there?
I think that would certainly get him to a jury. Whether there is something less than that, as I stand here, I can't foreclose that possibility. Maybe there is something less than that, but as I stand here, I can't think of what that might be either. And I would note, Judge Catani, that as I understand it from Vazirani's briefs, they don't argue that there are facts that would permit this kind of an inference. They just argue that it's not required. Their argument is it's the defendant's burden to prove that Vazirani was not damaged, and they don't cite any authority for that, and I think it's obvious why not, but I don't think the law supports that. If I may, I'd like to move to an additional ground for affirmance of the tortious interference claims, and that is that the interference is not improper. As a matter of law, the interference was not improper. There are many cases where, first of all, Vazirani has the burden of proof on improper. Wagenseller makes that clear. There are many cases, summary judgment cases, where this court has affirmed grant of summary judgment on the basis that the conduct interference is not improper as a matter of law. It's undisputed. The record, and I really encourage the court to look at the record if it has any concerns or questions. It's undisputed, though, that Advisors Excel and Creative One Marketing and Vazirani were competitors. They competed for agents and for premium production. And what the law says is because it's an at-will contract, a competitor can interfere, and as long as that's part of his motive, then that's not improper. As a matter of law, that's not improper. So when Mr. Bray argues this morning, well, that there's some evidence in the record that would support an inference that part of the motive was because they didn't like what Vazirani was reporting about other agents, that's immaterial, because the material question is on this record, could a jury find that none of these entities' motives was competition? And on this record, no reasonable juror could find that. Now, with respect to a nexus, they are not a competitor, but it's a similar situation. They have the authority to enforce the nexus rules, and under restatement section 773, as long as that's part of their motive, it's not improper as a matter of law. Next issue, if you even have to get to that, and again, you don't have to even to get to this issue unless you decide that Heights is not issue preclusive and the jury otherwise could find causation and resultant damage, but there's no improper means as a matter of law either.
Counsel, I want to switch gears for a second. The Nexus Shirts and the Nexus defendants had a communication. Shirts, who was with the Nexus, had communication with Phil Graham in North Carolina, and I think we went into that with your opposing counsel. And Nexus and Shirts were in Arizona.
Yes.
Why doesn't Arizona law, and it's only a defamation per se claim, why doesn't the defamation per se claim, why doesn't Arizona law apply to that communication?
Judge Kessler, if I may, I'd like to let Ms. Lovell address the questions, the specific questions regarding Nexus defense, and I'm going to sit down. If I may, I'd like to say two things briefly, and I'll get out of the way. One is with respect to my client, Creative One Marketing and Advisors Excel. I think there's no question that Kansas law applies, and Mr. Bray concedes that if Kansas law does apply, defamation per se claim fails. That's the end of the inquiry as far as we're concerned with respect to our clients. And with that, unless the court has other questions, I'll turn it over to Ms. Lovell to address Your Honor's questions about a nexus, and then I'd be happy to come back up and answer any additional questions.
One last question.
Sure.
Whatever happened to the injurious falsehood claim?
It was waived as to my client and as to Advisors Excel, and the court, as I recall, and Ms. Lovell would be able to address this better perhaps, I think the court granted summary judgment on that claim. At the same time, the court granted summary judgment on the defamation per se claim. It's
not in the briefs. No one ever addresses the injurious
falsehood.
falsehood.
I'm sorry. I'm thinking of trade libel.
Injurious falsehood is not in the briefs. So I'm assuming that's gone.
It is, Your Honor. Okay. Yes. Thank you.
Thank you, Your Honors. May it please the Court, I'm Andrea Lovell, and I represent the Annexus defendants. And just to start out with the injurious falsehood, Your Honors, right, and I think we dropped a footnote somewhere in our rather lengthy brief about the fact that injurious falsehood was waived on appeal. Addressing the choice of law issue that Judge Kessler raised, I think, and we briefed the issue, but I do think there are compelling reasons for Kansas law to apply even to the Annexus defendants, because Kansas really is where there was a relationship, if there was one at all, in the sense that the Aviva decision makers were located in Kansas. Aviva is who underwrites the Annexus product and who Mr. Vazirani had his contract with. And there's no allegation that any statement was made in Arizona. But Your Honors, I think we get...
There was a communication from Arizona to North Carolina.
Correct. I think
place of publication, but it's the place where the communication originated. That's the one
Right.
communication I'm concerned about having
Sure.
Kansas law apply.
Sure. Well, and even if Arizona law applies, Your Honor, I think we get to the same place in the sense that I don't think anything Mr. Schertz said was defamatory per se. And that's because restatement section 573 makes clear that to be defamatory per se, the comment would have to affect Mr. Vazirani in a way that is peculiarly harmful to someone engaged in his specific trade or profession.
You heard I summarized the statements that Schertz
Right.
made
Right.
to Graham. You don't think that is peculiar to at least the statement, no one in business wants to do business with him? That isn't peculiar to Mr. Vazirani's business reputation. And remember, this is all in the context of I think you agree, there's a two-step process in determining something is defamatory.
Right.
One is, can the court say in context it might be construed as defamatory? If it is, then it goes to the jury.
Right.
Why doesn't that meet that criteria of that first step?
I think, Your Honor, the case law would indicate that it would have to specifically relate to Mr. Vazirani's work in the life insurance and annuity industry. For example, the restatement comments compare and contrast two examples. One is if a doctor consorts with harlots, that's not defamatory per se, even though it's certainly not complimentary. But if a doctor makes advances inappropriately towards his or her patients, that specifically relates to the practice of medicine. And one of the cases we cited, Baker versus Trumco, I think, is a good case where the term referring to someone as having engaged in inappropriate sales practices was not enough. It was too general to constitute defamation per se.
Okay, so you're saying that the statement that Schertz made that his Aviva's contract's being terminated, he is done across the board, nobody wants to do business with the guy. I mean, any companies, but they're being held hostage. That's not enough.
Correct. And I think another case that may be instructive is the District of Arizona case we cited, Ultimate Creations, and that case addressed a comment about a plaintiff, and the comment, among others, was no one liked him and no one wanted to work with him. And the court in that case found that was not one of the statements the court found could be capable reasonably of a defamatory meaning. And I think that's very similar to the type of comment we have here, which courts have found to be rhetorical hyperbole. And I think Mr. Bray referred to the context being important, and I agree. I think the context here is a heat of the moment expression of frustration that no reasonable listener would have heard to be an assertion of fact by Mr. Schertz. And I am out of time. I'm so happy to answer any questions, though. Thank you.
Do we need to worry about Excel? See if Excel wants to say anything? He got sort of short.
Why don't we'll give you 2 minutes if you'd like, and we'll give you an extra 2 minutes as well.
If you need it.
If you need it. If you don't need it, you don't have to take it.
So it's one of the risks of saying, okay, I'll split time with someone, and I go second or third.
Yeah, I kind of figured I might get cut off. Garrett Alexa, Your Honors, on behalf of Advisors Excel, may it please the court. As Mr. Parrish alluded to, most of our defenses are closely aligned with those of creatives, and I think he's touched on most of those points. I just wanted to make sure the court didn't have any questions specifically related to Advisors Excel statements. If it doesn't, I'd make just one quick point, and that is with regard to defamation per se, and I think this applies to all of the appellees, is that we have multiple defenses in terms of Kansas law applies, but if Kansas law doesn't apply, the statements weren't defamatory. Even if you get past that, there's a critical qualified privilege. And in that particular situation, plaintiffs have failed to come forward with any proof of actual malice. And in fact, on page 38 of their opening brief, they said we're not even going to address that particular privilege argument. So they've essentially conceded that point.
Because the judge didn't address it below.
Right, but they could have addressed it. And finally, Your Honors, there's no evidence of actual harm. There's no evidence that the statements that were actually communicated in Arizona, and there's no evidence of actual harm to Mr. Vazirani's reputation. Thank you, Your Honors.
Thank you.
Good morning again. I just want to talk briefly about the Heights decision and why it's not issue preclusive and the procedural context in the case that it came up. Defendants had filed 2 separate summary judgment motions regarding Mr. Vazirani's tortious interference claim. And in both cases, the court below held, quote, questions of material facts still exist that require jury determination. And we think that that was the right result based on the record in front of you.
In this case?
In this case.
Yeah,
held that
understand.
twice. We think that's the right result, and we think
I would assume you would.
yeah, the judgment should be reversed for trial. So what changed? What changed was the motion for reconsideration filed by Mr. Parrish, citing the Heights case in the 10th Circuit in Kansas. Judge Kessler, you're correct. The only thing the court determined there that's really relevant was that the alleged interference by Mr. Heights and Mr. Canfield, who were Aviva executives, was not 100% motivated by personal interests. So, you know, that what logically flows from that is the court could have found that, you know, you don't know whether 99.9% of the motivation was sole personal interest, and it was 0.1% of this business justification regarding the changing market conditions for annuities.
But
So
they're pretty specific in the Heights. I mean, a reasonable juror could not believe defendants' motives for terminating Vazirani's contract were all unrelated to the business needs of Aviva. Both the lawyer's letter and Canfield's November conversation gave a business reason, focusing on Aviva's core groups that is uncontroverted, at least not by evidence as opposed to speculation, and led to terminations of thousands of other agents. The evidence supporting the other reason given by Canfield, Vazirani's improper business practices, is compelling and uncontradicted in its essentials.
again,
That's
Judge
pretty much-
Kessler, I would say it goes back to the standard, which is the standard is different in that case than this case, that it had to be solely motivated by personal interest. And the quote that you gave, the 10th Circuit said a jury couldn't believe that they were all, quote unquote, all unrelated to business reasons. So again, I think it goes to my point is that there could have been a de minimis
Right.
business
But
reason.
their argument is you have to show a reasonable assurance that it was going to continue.
What is your best evidence that there was a reasonable assurance that the contract would have continued without the improper statements?
Sure. I would answer that in 2 ways. Number one, based on the record before it, the court found twice that there was a reasonable assurance implicitly in its prior denials of the motions for summary judgment. The Heights decision should not have changed anything. And the nature of the issue in terms of what Mr. Parrish talked about in terms of causation and damages, to me, are inherently factual. And I think our best evidence was there were that Mr. Vazirani was affiliated with Financial Independence Group, which was a key core group of Aviva, contrary to the representation in the letter they sent Mr. Vazirani when they notified him they were going to terminate, or the reason for the termination, that Mr. Vazirani was a top producer, and that people within Aviva that weren't affiliated or on the side of appellees who were attempting to interfere with this contract, such as Justin Jacquinot, who was Mr. Vazirani's contact person at Aviva, said there were no, I forget the exact quote, but basically no red flags, and that he thought the contract should continue. So, I think the analysis of that issue is you're necessarily weighing the evidence, and it's a fact issue for the jury.
These contracts were not automatically renewable, were they?
No, they continued. I don't think they were for a particular term. They continued until one party or the other either terminated them for cause or without cause. In terms of the producer contract, if that's what you're referring to, Mr.
If they can be
Vazirani.
terminated without cause, if someone just doesn't like your client personally, that it's not an improper, that there's no obligation to renew the contract.
Sure. I mean, we don't have a claim. We did not assert a claim against Aviva that it was a breach of the contract or a breach of the implied covenant of good faith and fair dealing for them to terminate the contract without cause. What our argument is even if you have a at-will contract with a termination without cause clause, that does not give businesses and entities, such as appellees in this case, the right to wrongfully interfere with that contract.
But you
That's our
still got to
argument.
show there's a reasonable assurance it would continue.
Pardon me?
In the at-will context, you have to show a reasonable assurance that it would continue.
Well, I would say, number one, they primarily relied on a Kansas case for this reasonable assurance element. That's not specifically in the wagon seller
But it's
decision.
in the restatement.
And with regard to that, the reasonable assurance, I would say that, again, that's an inherently factual issue based on the record,
But the evidence you're looking at is the Jacquinot statement.
among other things, among the fact that he was affiliated with Financial Independence Group and that he was a key producer for a number of years for Aviva.
Isn't there evidence of that other people who were similarly situated were treated the same, even high producers, contracts were not renewed?
There is evidence along those lines.
One last.
But again, if you look at the actual basis why they did it, it had nothing to do with the change in business plans or the Lehman Brothers crash and the bubble for annuities. It had to do with the fact that we want to do it for shirts, which I think is the exact quote. Happy to do it for shirts, don't want to do it for Advisors Excel.
But,
And Shirts, of course, was the author of the defamatory statements, the false defamatory statements that nobody wants to do business with them when they do.
one last question. Your best argument why this doesn't, as far as the defamatory, the allegedly defamatory statements by Shirts to Graham, they cite to Baker and Ultimate to say this is really just hyperbole. It doesn't mount to defamation per se. How do you respond to that?
I think the only way I can respond is I understand it's a gray line between hyperbole and a statement of fact. And I think in the context of the entire conversation, and you read a good portion of it, Judge Kessler, that he's making statements of fact regarding Mr. Vazirani, and it's not mere hyperbole. Any other questions? Thank you.
Thanks to all of you for your arguments. We will take this matter under advisement and issue a decision in due course. And with that, we're adjourned.